let's get ready to rumble. Okay, here we go. Brokerage relationships agency law. When can a broker reveal confidential information about a client? Under no circumstances, never, under subpoena, or when the listing expires. All right, there we go. Yes, under subpoena. And actually, that's a typo. It should be an N there. Subpoena. All right, so under subpoena. So yeah, if it's court ordered, yes, you can reveal confidential information. When the listing expires in Ohio, no, you are not allowed to talk about any confidential information about your client. That is your, that goes back to the trust and responsibility to the client. So never would be the right answer, except in the situation. And maybe you pick never because subpoena was spelled wrong, and you're like, that's a trick question. So this is the circumstance when you are court ordered to do so. All right. A couple of you out to an early start. Becky and Mariano duking it out. A consumer guide to agency relationships form must be provided for all of the following except a single family residence, a two-family residence, a condominium, or an office building. All right, yes, an office building. So whoever picks single family residence, that's like the case where it absolutely should. Also, all of the other ones, anytime it's residential. So any of your residential properties, you're going to have a consumer guide to agency. So it's once you go into commercial, that changes the game. So an office building would be commercial. All of those other properties are considered residential. Hey, Stephanie, welcome to the Zoom. All right, so let's move on. All right, so Stephanie, we are doing the state portion of the exam. We're focusing on brokerage relationships, agency law right now. All right, next up. What would not cause a real estate sales agent to lose her license? Violation of the canons of ethics, a felony conviction for embezzlement, a second violation of a fair housing law, or a violation of the code of ethics? Ooh, only one answer so far. This is a stumper, huh? All right. So yes, code of ethics. So good reading there. Everyone read it once it uncovered. And I appreciate the person who said a felony conviction for embezzlement. So embezzlement is actually a cause that you could lose your license because anytime you do anything dealing with money where you're in violation of the law with money, they're going to take your license away because you deal with the most valuable asset that most people have in their life. And so if you've got money violations or a felony conviction on money, you can almost guarantee that you're going to lose your license over that. Same thing with, and remember, the code of ethics is with the National Association of Realtors. The canons of ethics are with the state. So if you violate those, yes, you can lose your license. And of course, fair housing law, you can also lose your license there. All right, Becky on fire, streak of 3. Let's go, Becky. A seller dies during a 90-day listing agreement. What is true? The agency agreement is terminated by operation of law. The broker can sue the seller's estate for specific performance. The agency agreement is still in full force and effect, or the sales agent can sue the seller's estate for specific performance. Oh, only 2. So that was a stumper too. Okay, yes. So it is the agency agreement is terminated by operation of law. Stephanie, I see your hand. You have a question on that? Okay. All right. So yeah, it's terminated by operational law. If a seller dies, then that pretty much immediately terminates the the cover shouldn't pop up. That's cheap. Well, we want this to move fast. So, and your points are based on how fast you answer the question. So if you know the answer and do it quickly, you get more points than someone who took longer to answer that question. So yes, it's cheating. And of course, and it's not really cheating. It's helping you understand the answer without me having to explain it all. And somebody said the agency agreement is still in full force and effect. No, that is incorrect because, like I said, if a seller dies, that terminates the agreement. And the sales agent can sue the seller's estate for specific performance. Technically, no, because the sales agent isn't actually in that agreement. The agreement is between the seller and the broker. So the seller and the firm have the agreement. The sales agent is not part of that agreement, so they can't sue, or they wouldn't have a leg to stand on if they tried. All right. Becky still killing it. Becky's got the state down. Trustee on the move. Which fiduciary duty survives the termination of a real estate listing? Confidentiality, financing, obedience, or loyalty? We actually just talked about this. So we all should have gotten this one right because we just went over this one. There you go. Yeah, I mean, I understand loyalty, but it's confidentiality. Just like we said, the only thing that can cause a person to reveal confidential information about a client after the fact is a subpoena with the court. So loyalty, I mean, if you're working with someone on the other side of a deal, you don't necessarily have to be loyal to them after the agreement. So the loyalty expires with the agreement. Mariano on the move. Becky killing it. What is not a fiduciary duty of an Ohio real estate licensee? Loan arranging, accountability, care, or obedience? Forgot to cover that question. All right, and still, all right. Yeah, so loan arranging. That's not your responsibility. You have nothing to do with the loan. You're not a lender. That's not your job. And the thing to remember about being a real estate agent is stay in your lane. You're not a tax advisor. You're not a lender. You're not a lawyer. Stay in your lane. All right. So, yeah, care, obedience, and accountability, those are all part of your duties as a real estate agent. Oh, trustee. Becky dropping back. Trustee is on the move. Man, nice. The relationship in which the agent is placed in the position of trust and confidence is described as implied agency, fiduciary, disclosure, or brokerage. It's too bad you can't pick which squares disappear first. It was the only word you could see. All right, fiduciary. Everybody got that one right. When a salesperson is offering an overpriced property, he should not quote the price, discourage prospects from looking at the property, quote only the listing price, or tell the prospect what he thinks the price should be. All right. Yes. Your responsibility is to give the facts. So if you're saying not quote the price, part of your duty is honesty. So if that's pretty much lying by omission. And same thing with tell the prospects what he thinks the price should be. Your job is to give the facts of what it is, not necessarily put your opinions on it. I've learned that in many years of real estate that, you know, you be careful walking into a house and be like, this place is a dump, you know, because that client may be like, this is the most amazing place I've ever seen. I love it. And you just basically steered them away from the property. So keep your opinions to yourself and use facts. All right. Question number 9. What is an ethical standard that must be followed by an Ohio real estate sales associate? Treat both buyer and seller equally. Treat all people honestly and fairly. Treat all people as you would have them treat you, or treat all people with honor and dignity. An ethical standard. Okay. All right. Treat all people honestly and fairly. So it would make sense to say honor and dignity, and at the same time, the ethical standard is honest and fair. So when you're asked certain questions like the canons of ethics, the code of ethics, so we want honest and fair. All right, already jumping on the board. A sales agent represents a seller in a listing. What are the agent's duties to the customer, the buyer? Honesty and fairness, loyalty. Loyalty's in there twice, so it must be important. Care and accountability. We just talked about it. Yep, honesty and fairness. So that is your responsibility to all people as a real estate agent. And remember, according to, you know, anytime the law is involved, your job as a real estate agent is 24 hours a day, 7 days a week, 365 days a year. You are always a real estate agent. And if you don't treat people with honesty and fairness in regards to real estate, then there can be a problem. So your job is honesty and fairness at all times when it comes to real estate. All right. Lakia jumping on the board, making the move. What is not the unauthorized practice of law? Completing a pre-printed sales contract form, preparing a real estate land contract, preparing a real estate sales contract, or preparing a real estate lease. So what is not the unauthorized practice of law? See some people jumped in on the end there. All right, this one was a confusing one for people. So you can complete a pre-printed sales contract form, because what that means is a lawyer wrote it. You're just filling in the blanks. When you say preparing something, that means you're creating it. So if you're preparing a real estate land contract, you're writing it. If you're preparing a real estate sales contract, you're writing it. And same thing with preparing a real estate lease. So you can complete a pre-printed form. You cannot prepare any documents, because then you are doing the unauthorized practice of law. Like I said, stay in your lane. You're not a lawyer. Already on the move. Wow, trustee with a streak of 10. Woo-wee. A broker lists a home. This agreement can be terminated by all of the following except death of a salesperson, death of the seller, broker bankruptcy, death of the broker. So only one is the exception. And it is death of a salesperson. All right, so death of a broker. If the broker dies, all the deal, that's where all the deals are. And remember, the salesperson is not part of the actual contract. It is between the seller and the broker. So, you know, the broker and the seller are the two people involved in the contract. The salesperson is the intermediary. They are acting on behalf of the brokerage. So you're not in agreement with, so the death of a salesperson doesn't terminate a contract. Only the brokerage. and seller and broker bankruptcy, because if the broker goes bankrupt, that terminates too. Okay, no movement. X lists the property. X finds a buyer. If X is allowed to write an offer as a buyer's representative, no, an agent cannot collect both commissions. No, it's against federal trade laws. Or yes, as long as both parties agree in writing. Or yes, if it is specifically written in the offer. So the agent lists the property, they found a buyer, can they write the offer as the buyer representative? All right, you all got it right. So yes, dual agency can be done as long as you have it agreed upon in writing by both. Already on fire, 7 answers in a row. A buyer should never hear his or her real estate agent say which of the following: I cannot take that offer to the seller. I cannot act as a dual agent per broker policy. I cannot withhold any offers, even poor ones, or I cannot withhold hidden defects. Okay, a little confusion now on that one. So a broker should never hear his real estate agent say which of the following. So a buyer should never hear his say which of the following. Yeah, I mean, they should say, I cannot withhold hidden defects. You know, if somebody says, you know, if they know of a defect, they have to disclose it. And so, you know, cannot take that offer to the seller. Your job is to obedience. If they say, I want to make this offer, you have to take that to the seller. And same thing with the listing agent. I tell my sellers all the time that, you know, if I get an offer for $50 on your $500,000 home, I have to bring it to you. So don't kill the messenger, because my job is to present all offers, no matter what they are or how silly they may seem. And, you know, my job is to present them. So, you know, I cannot take that offer to the seller is not an option. All right. Who is not an agent or sub-agent? A salesperson employed by a broker, a non-licensed person assistant of an agent, a broker who is listed in owner's home for sale, or a property manager managing property for others. Not an agent or sub-agent. Okay, good job. A non-licensed personal assistant of an agent. Yep. Property managers are required to be licensed and are agents. All right, Mariano, back on the board. Which would cause a real estate sales agent to lose his Ohio state license? A violation of the canons of ethics, a violation of the Board of Realtors Code of Professional Responsibility, violation of the Code of Ethics, or violation of a minor traffic offense. So we went over this one earlier too. Why not blue? Oh, sorry. I don't remember what blue was. All right. Yes, violation of the canons of ethics. So as we discussed earlier, the canons of ethics deal with the state. Code of ethics is with the National Association of Realtors. It's not a, you know, it's not a law organization. It's, you know, it's a membership organization, whereas the state deals with the canons of ethics. So anything Board of Realtors, National Association of Realtors, you know, you can get fined, you can get different things, but they're not, they don't hold your license, the state does. Okay. Alrighty. Moving to the top. Moving to the top. A real estate licensee owes the fiduciary duty of confidentiality to the seller until 1 year after the contract, forever. It expires when the contract expires, until paid the commission. So yes, forever, just like we, and notice a trend here. A question that came up a few times is probably a question you're going to see on your exam. And your fiduciary duty of confidentiality is forever, unless subpoenaed and brought up in court. So that's the only time you can break that responsibility. So it does not expire. It goes on forever. All right, who's the winner? Becky at number 3. Already stayed at number 2. And that leaves Trustee at the top. All right, runners up are Lakia and Emily. Okay. All right, so let's go back. And let's do the brokerage relationships, contracts, practice, financing, general principles of agency. Hang on a second. Let me share my screen again. License law and the rules of the Ohio Real Estate Commission. Real estate recovery fund claims are limited to what dollar amount? $2,500, $40,000, $100,000, or $800,000? Got some readers. 40,000. That is right. Let's see who the people were that answered quickly. Already. All right. And Mariano were the top 2. Number 2, under what condition can an assistant talk with a client about the terms of an offer? When the assistant has the authority of the agent, when all the agents are out of the office, when the assistant has a license to practice real estate, or when the client does not mind dealing with the assistant. When can they talk about terms of an offer? Okay, so when the assistant has the authority of the agent. So the assistant with the authority of the agent can fill out forms and do certain things. They cannot talk about terms. And same thing when all the agents are out of the office. No, still can't talk to the client about terms. They would have to be licensed in order to do that. So remember, as an agent, there's 5 jobs of a real estate agent: lead generation, lead follow-up, going on appointments, negotiating contracts, and then practice and role play. So the negotiating contracts, talking to clients about terms, that's an agent's job. So if you are not licensed, you cannot do that. Okay, got some movement on the board. It's an open game. A seller gave her agent a check for getting her house sold so quickly. What must the salesperson do with the check? Give the check back to the seller, give the check to his broker, keep the check regardless of the amount, or the agent may keep the check if it's less than $10,000. Give it to the broker. So give the check back to the seller. You don't have to give it back. You can keep the money. You just got to give it to the broker and let them disperse funds to you. Remember, your brokerage is who pays you. The client can't pay you. It's your brokerage. So you have to be paid through your firm. So anytime you get payment, you give it to your firm and then they disperse that money to you. All right. The rate of commission that may be charged on the sale of improved property is the rate agreed upon between the buyer and the sales associate, the rate agreed upon between the broker and the sales associate, 6%, or the rate agreed upon between the broker and the property owner. All right. Yes. Remember, between the buyer and the sales associate. So when you're doing the sale, the commission, the seller pays commission. So the commission is from the seller side. So the buyer would have nothing to do with that agreement. And again, the sales associate isn't actually the one that establishes, you can negotiate on behalf of the brokerage, but it's an agreement between the brokerage and the property owner. So the seller is who. So what if the client write check only to you? You would have to have them write the check to your brokerage. If they write the check to you, yes. And that, I see what you, so maybe you were the one that said you had to give the check back. Yeah. You would have to make it so that it goes to the brokerage and then they pay you out of that. So again, I want to point out that technically you were right. If you wrote that you had to give the check back, you were right on a technicality. And in the test, you'll find that, I took the Ohio test as a person who had been practicing real estate for several years. And there were several questions where I was like, well, not in this case, or, that's not always true. The test is basically, saying the simplest answer, the Occam's razor kind of thing. The simplest answer is usually the correct one. So, in those situations, go with, what they're looking for. And they're looking for the brokerage has to pay you. Think about what the test is about. It's about license laws and agency relationships. This is license laws. And the law says you have to be paid by the brokerage and not by the person. Not necessarily that you have to give the check back. It's more making sure that you have to be paid by the brokerage and that other people can't pay you. So whoever's written on the line, you're making an inference there. And so, even though they gave you a check, you're assuming that they wrote your name on it. Don't assume, just look for what they're asking. So they will ask questions like that. And your job is to be careful on how you read it and look for the answer that they want, because there might be a couple that seem right. So hopefully that's helpful. So yeah, the rate agreed on by the property owner and the broker. And I was answering the question in everyone for the last question. All right, who can be affected by lead poisoning? Is it children, elderly, anyone, or pregnant women? It's anyone. All right, good job. See, that's another way. They know that lead poisoning, the law was put in place because of children, and anyone can be affected. So it's one of those where they're hoping you say children because that's the knee-jerk reaction, and all of you got it right, so great job. What law requires a broker's license to be placed in close proximity to the Federal Fair Housing poster? Ohio Civil Rights Act, Federal Fair Housing Act, Ohio Licensing Law, or Real Estate Settlement Procedures Act? There we go. All right. Yes, it is the Ohio Licensing Law. So Federal Fair Housing Act. Okay. I'm surprised by that. And yes, you would think because it's the Federal Fair Housing poster, but remember, we're in the state portion of the exam. So the state portion of the exam, the Ohio Licensing Law requires the broker's license. It requires the placement in where the posters have to be. Federal Fair Housing Act will say what's on the poster and that kind of thing. We got a question from TG. Go ahead. You're muted if you're talking. You got your hand up. I don't know if you mute.
Okay. So if this question was on the national, how will it appear on the national, I should say?
They might have something similar to it, like what things have to appear on the Federal Fair Housing poster, but this is talking about your broker's license. So the question isn't really about the Federal Fair Housing poster, just that it has to be in close proximity to it. So the question is really about where your broker's license has to be displayed. So, that's the thing to look at, is they put words in there to make you think, oh, Federal Fair Housing. You see that and it's like, oh, I'm going to pick that one. But the question is really about your broker's license and placement of the broker's license in the office. So, and that's a state thing.
Okie dokie, thanks.
No problem. I think we're all confused about block busting. Well, that's not really a question we're dealing with. And at the same time, if you look at the history of real estate, block busting is, so say there was a neighborhood that I wanted to take over as a real estate agent, and I started, this is going to be hard to say. So I brought in some undesirable element into that neighborhood. So say I started releasing like coyotes or baboons into the neighborhood. Is the test broken out in sections? It's kind of all random. But again, it's all random. And at the same time, the reason I say pay attention to the questions is because if you look at what's the most important part of that question, you can figure out it's not about Federal Fair Housing, it's about broker's license. But back to the block busting. If I released a bunch of baboons on the street and I said, or snakes or whatever, and said, oh man, this place is being overrun by snakes, you guys all got to get out. And I sell everybody's house because I'm creating a panic. And then I round up all the snakes because I released them. And then I say, okay, now I'm going to sell this old neighborhood again. And the way block busting actually, it's basically pushing people out of a neighborhood to bring in new people to force sales of homes. So that's block busting. Creating a panic, so to speak, so people leave their homes and sell through you, and you create, kind of a flight situation. All right. Not again at the top. Okay. At what point must earnest money be deposited into the broker's trust account? Immediately. Within 48 hours or the terms of the contract, whichever comes first, once the offer is accepted, or according to the terms of the contract. According to the terms of the contract. So you would think immediately, because it's typically it's going to say on a contract due upon creation of a contract. And it's whatever the contract says. So it could be within 5 days, it could be whatever the contract says, because the contract is the rules of the agreement. So whatever's in the contract is what stands. That's what a judge or anyone's going to go off of, is, what does the contract say? And that's it. Because any dispute upon when it should have gone or when it shouldn't have gone, all that other stuff is out the window if the contract says it. You can create an addendum or something like that to change the contract, but again, that becomes part of the contract. So yeah, not immediately, not once the offer is accepted, even though a lot of contracts will say that. They'll say it in the contract, but the answer is whatever the contract says. All right, no movement. What lien automatically attaches to a commercial property to secure a broker's commission? Attachment lien, a broker lien, a mechanic's lien, or a judgment lien? So a broker's lien. All right. Everybody got that one. The closing occurred on September 30th, 2012. Under Ohio licensing law, the soonest the broker can dispose of the file is December 31st, 2012, September 30th, 2015, or September 30th, 2019. Oh, this is not everyone knows this one. Yep, it's 3 years. The requirement is to keep your files for 3 years. I will say digital files are acceptable in this day and age, so it makes it a whole lot easier than keeping a bunch of paper files in boxes for 3 years, especially if you're a busy agent, because you have to keep everything. What protected group is covered under the Ohio Civil Rights Law, but not under the Federal Civil Rights Law of 1968? National origin, ancestry, handicap, or sex? Ancestry. All right, we got that right except one. All right, last question. How many hours of continuing education are required by an Ohio licensee over a 3-year reporting period? 20 hours, 26 hours, 35 hours, or 30 hours? $30 hours. Yeah. So you got to do 30 hours every 3 years. So it's essentially 10 hours a year for 3 years, and that's your continuing education requirement. There's lots of free continuing ed out there. I hate these. Okay. Tell me more, TJ. What's the problem with these questions?
It's those the one about what act was left out of the civil rights law, the Ohio, those ones. See, okay. I can't even remember. I can't even repeat the question. That's why because I'll never always get it right. The fair housing, not the fair housing.
Wait.
Forget it. I can't focus. I can't think right now.
Okay.
I want to hold up the class.
All right. Well, we're done. We've only got 5 minutes left, so I'm opening it up to questions. Anything that people feel they want to ask about the test or anything coming up or real estate in general. So I'm gonna go ahead and resume. All right. We're in Civil Rights Act. Already, and not again. Not again, number 1. All right. So, last 5 minutes. Any questions? Any feedback? Now's your time.
I guess I get confused with those, the Ohio Civil Rights Commission, the Fair Housing Act with the discriminatory. I can't even find it. It was like the 5th. It was just that question.
Okay, hang on.
Maybe like the 5th from the last one, or the 4th, one of the last 5 questions, I want to say.
So license laws. Under what conditions, right, who can be affected? What protected group is covered under the Ohio Civil Rights Law, but not
Yes.
under the federal Civil Rights Law of 1968?
Yes, those ones. I can't never, because most of them got the same thing, and I can't remember the difference.
Yeah, Ancestry is not part of it. What was the thing? Fresh Corn? Is that the acronym for the federal civil rights law? Is that the acronym? Anybody?
Yeah, I've heard that before.
Yeah, so Ancestry is not part of that. So that's how you know the difference. Yeah. So yeah, Fresh Corn.
Okay.
Okay. All right. And thank you, Long.
Thank you.
Yeah. Anything else? You've got me for the next 2 minutes.
Look, we'll see you next Tuesday.
All right. Well, I'm going to give you back 2 minutes of your lives. Enjoy it. Have a great night.